Welcome back to This Week in Immigration. I'm your host, Jack Malday, Associate Director at the Bipartisan Policy Center. In this week's episode, BBC Senior Advisor Theresa Cardinal Brown welcomes two guests to delve into the recent Supreme Court decision to overturn the 40-year-old judicial doctrine of deference to executive agencies that has been defining American administrative law, and the impacts for US immigration policy and legal practices. Our first guest, J.D. Rackey, Senior Policy Analyst at the Bipartisan Policy Center's Structural Democracy Project, will help us understand the history of the so-called Chevron doctrine and its overruling, and give us a broad picture of the impact on the legislative and executive branches of government. Then, Mark Stevens, a top-rated Washington, D.C. lawyer with expertise in immigration litigation, will join us to explain how the SCOTUS decision changes legal practice for immigration attorneys and their clients. Since it's all about the courts today, let's call this a new episode of The Gavel. Stay tuned.
On June 28th, the Supreme Court made a landmark decision that promises to very much affect the way the federal government, governs. The case combined two different suits, Loper Bright Enterprises versus Raimondo and Relentless versus Department of Commerce, and overturned the 40-year-old standard of deference that courts gave to federal agency rulemaking, known as Chevron deference, after the original Supreme Court case. We obviously couldn't have missed the opportunity to discuss this groundbreaking decision on our podcast as well. So first, to talk about the ways this case might affect the balance of power between the executive and legislative branches generally, I'm thrilled to welcome my colleague from the Bipartisan Policy Center's Structural Democracy Project, Senior Policy Analyst J.D. Rackey. J.D. works on the governing institutions and electoral systems portfolios of that project. His research focuses on the politics and procedures of the U.S. Congress, with an emphasis on congressional capacity and modernization. His work has been published and cited in scholarly journals and popular press outlets, and he also currently serves as a council member for the National Capital Area Political Science Association. Prior to joining BPC, J.D. gained his experience as the Director of Legislative Studies and head of the Congressional Reform Program at the Sunwater Institute. He was professional staff with the U.S. House of Representatives Select Committee on the Modernization of Congress and an adjunct lecturer at Georgetown University. So welcome to our podcast, J.D.
Thanks for having me. It's great to be here.
So to start, let's just get back to basics a little bit. Can you help our audience understand what the Chevron deference doctrine was, the case in its original ruling from 1984, and how has it been affecting sort of the American legislative and executive branches' power balance since then?
Sure. So that case involved a legal challenge to the government's interpretation of what the word source of air pollutants means, coming from the Clean Air Act of 1963. The act did not precisely define what constituted a source of air pollution, and the EPA initially defined source to cover essentially any significant change or addition of a plant or factory. In 1981, under the Reagan administration, the EPA changed its definition to mean only an entire plant or factory rather than individual kind of stacks. This allowed companies to build new projects without having to go through a new and lengthy review process from the EPA. The Natural Resources Defense Council sued the EPA, challenging the legality of the EPA's new definition. And what the court ruled unanimously in 1984, 6-0, was that they ruled in favor of the new EPA rule, arguing that the vagueness of the term source in the Clean Air Act indicated that Congress had delegated to the EPA the power to make a policy decision in determining the definition of the term source and thus subsequent regulations necessary to meet the goals of the Clean Air Act. The decision also set up a two-step process that courts have used ever since this ruling to interpret agency rulemaking and whether it fits within congressional intent. And the two steps are, one, is the statute clear? And if the statute set out by Congress is clear, then agencies have to follow the statute. But two, if the statute is not clear, does the agency's interpretation fit a reasonable understanding of what the statute was meant to be? And so since then, it's created a policymaking environment that has allowed Congress to write sort of vague statutes that focus more on the broad goals of legislation rather than the specifics of implementation. And it has meant that courts have had to defer to agency interpretation of statute more often than not.
Yeah. So let's talk about these two cases, which were combined at the Supreme Court, Relentless and Loper Bright. What happened there, and what was this new ruling?
Yeah. So Loper is really where the meat of this case and the ruling came from, and it focused around the National Marine Fisheries Service and what regulations that service could create under the auspices of the Magnuson-Stevens Fishery Conservation and Management Act of 1976. That's quite a mouthful. The act gave the fishery service the authority to implement comprehensive fishery management program, and that the program is allowed to require that one or more observers from the federal government be aboard a vessel for the purposes of collecting data. And the service created a rule under the act saying that commercial fishing companies have to pay the costs of having a federal monitor on board, which are estimated to be about $710 per day. Loper Bright Enterprises led commercial fisheries in challenging that rule, claiming that the act did not, in fact, give the fishery service the authority to promulgate that rule.
So that's what the suit was about. But obviously, everybody's like talking about this because this has far wider ramifications than just the fisheries service. Because the Supreme Court decided to undo what it had done 40 years ago. So tell us about what the decision was, and how we see that sort of rippling out, to use a metaphor, about fisheries from this case.
So the Loper decision focuses on step 2 of the Chevron deference test. And the court ruled that courts, not executive branch agencies, should determine whether a regulation is within the bounds of what a statute set forth by Congress is meant to be. Roberts explained in his opinion that for the court that Chevron deference is inconsistent with the Administrative Procedures Act, which is a federal law that sets out the procedures that federal agencies must follow, as well as instructions for courts when it's reviewing actions of those agencies. And Roberts noted that the APA directs courts to decide legal questions by applying their own judgment, and therefore makes clear that agency interpretations of statutes, like agency interpretations of the Constitution, are not entitled to deference under the APA. Roberts concluded that it thus remains the responsibility of the court to decide whether the law means what the agency says it means. Still, though, the ruling did leave in place a kind of less strict level of deference known as Skidmore deference, which says that the courts should take agency interpretations into consideration when they are deciding a case, but that they do not automatically have to defer to those agency interpretations.
Yeah, so there's a lot to unpack there. Let's start with the Administrative Procedures Act. We've talked a lot on this podcast about the importance of the Administrative Procedures Act because the immigration system is governed by a lot of agency actions and rulemakings. It's a civil process for the most part, and we've seen a lot of court cases over the last several years be decided on the Administrative Procedures Act, and there are two basic big chunks of agency rulemaking. And one is that the agency can only do a rule that's within its authority and statute, right? And if it goes outside the statute, then that rulemaking is not appropriate under the administrative. And the second is sort of a procedural way. You have to do it in a certain way with like notice and comment, and take into consideration what the public has to say about it and those who are impacted and all of those kinds of things. And some court cases brought against agency actions have fallen on the first part, that they went outside the statute, but more and more it's about the procedural side of things. Now that may change here. I think that's what we're seeing, is that particular, that first part, is the agency acting within the statute, is going to be bigger. So that means that the role of the statute and how the statute is written is really important here, because the courts are going to be looking at that first. So you recently co-authored a blog post for BPC that discusses the implications of this on Congress, and what it might mean for Congress. So, what do we expect in a post-Chevron world in the work of Congress and the executive branch, the agencies, and the judiciary? How's it going to change sort of how they relate to each other?
Yeah, so I think that it's really important to point out that the ruling affects two relationships, both Congress's relationship to the executive branch and the executive branch to the courts. And so for the executive branch, I think agencies will have to be much more careful in how they interpret existing statutes as they promulgate regulations. However, at this point, it's unclear just how much that will alter what agencies are doing, given that Skidmore deference still stands. For the judiciary, it sets them up to be in a very interesting position. On one hand, it could give courts more ability to assert themselves in the policymaking process by interpreting vastly more regulations than they have in the past. However, that means a huge increase in the judiciary's workload as more litigation is brought forward seeking to overturn regulations. But it should be noted that the federal courts are already tremendously overburdened by the number of cases that they are facing, and they don't have enough resources, enough judges, enough clerks, enough time to process their caseload in a reasonable amount of time. And so this probably only adds to their burden. For Congress, Congress is stuck in a bit of a waiting game, I would say. On one hand, we've seen already actions from House Republicans sending letters to agencies to demand the review of what they deem to be overreaching regulations in the wake of the decision, saying that, we want you to review these things because they might have stood pre Loper under Chevron deference, but they might not anymore, and we want you to be prepared to remove them. More broadly, I argue Congress should be working to increase its capacity so that it could be more specific in how it actually writes statutes so that their intent is made clear rather than allowing the court's wide discretion in interpreting congressional intent.
So, that there's a lot there. um, you've written, and our BPC has written a lot about the capacity of Congress to legislate and to do more work. And one of the issues in the Modernization Committee and the recommendations BPC had is that Congress is going to lead a lot more staff, and a lot more staff with detailed understanding of the policy areas it's legislating in, to write that specific type of law. Is that your understanding as well? Like there's not a lot of expertise. Like I'm thinking complicated areas like AI. I mean, immigration is complicated too, don't get me wrong, but like there are a lot of things on its plate that are just really hard for many people to understand.
Right. And this comes at a time w- when Congress has been at a 30-year decline of capacity. The Modernization Committee that I worked for and that BPC gave lots of recommendations to has been working the past 4 or 5 years to help kind of reverse that trend and in increasing Congress's institutional knowledge by doing things like increasing staff pay so that there's less turnover, so that as people acquire expertise within the institution, they're incentivized to stay. But we've also seen from the 90s through now a declining in the number of congressional committee staff, a declining in the number of staff at the support agencies like the Congressional Research Service and the Government Accountability Office, and those are Congress's internal think tanks. And so decreased capacity for them really hurts Congress's ability to have in-house expertise, and particularly complicated policy areas like that relate to science and technology. Congress has very little in-house expertise, thanks to in the 90s they zeroed out and got rid of the Office of Technology Assessment, which was Congress's scientific brain. It's not entirely doom and gloom. Recently, there's been the STAA, whose science technology. I'm forgetting the acronym, but an entity within the GAO that is focused on science and technology innovation and explaining new technology to Congress has been stood up, though it probably, as we argue in the blog post we wrote, could use many more resources, particularly after this decision.
Yeah. So in your blog post, you cited Jennifer Palka, who is founder and former CEO of Code for America. So she comes from a technology background, but she talked in her paper about the disconnect between how Congress drafts laws and how that language is interpreted by the agencies. Could you explain more to our audience who may not have read a lot of legislative language what the process is on Capitol Hill for writing bills, and where and then what happens once it's enacted? How do the agencies then look at it?
Yeah, so I think historically Congress has preferred to write rather vague statutes that list out more broad goals of what they hope legislation will achieve. For example, the Clean Air Act's goal was to make the air cleaner, right?
Mhm. Yeah.
Rather than getting into the specifics of how to make the air cleaner. They might have, gone into some detail of areas in which that the agencies could work to do that, but a lot of the nitty gritty, as we saw in the original Chevron case, of defining sources of air pollutants, they left to the executive branch. Congress has historically, all the way back to the founding, chosen to write rather vague laws. Madison talked about the necessity for legislatures to do this, because could be difficult to find the words that can fully encapsulate all of the nitty gritty of policymaking.
Mhm.
Nor can legislatures necessarily predict all of the circumstances within which a law might be interpreted. But in Jen's book, she talks about where policy and implementation meets technology a lot. So, for example, she talks about expanded access to unemployment insurance during the pandemic. And Congress said, we want to expand unemployment insurance, and they appropriated money to allow that to happen. But the states had to implement it. And state systems vary widely, and the technology that supports state systems tends to be very outdated. And so the system collapsed under increased demand, ultimately delaying or denying benefits to people who were legally eligible for them, which is kind of an example of where legislators set broad goals, such as increased access to unemployment insurance, but did not think through how bureaucracy can implement such goals, and the challenges to that.
Yeah, I think we've talked a lot on this podcast in the immigration space about how, Congress can mandate a thing to be done, but the logistics of actually doing that thing can be quite complicated. I'm thinking specifically about border enforcement or detention, and it also requires resources. So they may mandate that the government do something and then not provide the resources to do it,
Right.
right? So that sort of where the legislation hits the actual operations is a big issue in immigration, and I'm sure, as you mentioned, in a lot of other areas.
I'll just add, Congress does that for a couple of reasons. One, it's easier for Congress to maintain legislative coalitions by being vague,
Mm.
right?
Hmm.
It is easier to agree on broad goals than it is to, back to the Chevron example, agree on what a source of air pollutant is, right? It's easier to say we all agree we want clean air, but it's more difficult to be more narrowed. And then the second reason they do it is that and there's a lot of political science research backing this up, is that Congress prefers to take positions on things and claim credit for having set a goal rather than getting into the weeds of implementation. And they rather just conduct oversight on the back end and kind of blame the executive branch for failed implementation. It's just,
It's
and
never
this
Congress's fault.
no, and this is bipartisan. This
Yeah.
is not particular to this Congress. This is Congress from the very beginning, and I would argue legislatures the world over. That's just kind of how they operate and what they're incentivized to do.
Yeah. So at the end of your blog post, you provide several considerations Congress must weigh as it adjusts to this new policymaking environment. So, what are they?
Yeah, so I guess first I would stress that these are considerations Congress should weigh if it wants to assert primacy in the policymaking space rather than ceding authority to the federal courts. And we kind of grouped these considerations into two categories: procedural and capacity. On the procedural front, Congress should probably consider revising or expanding the Congressional Review Act, which is the act that allows for Congress to express disapproval of a pending regulation and that is not reviewable by the courts. And maybe Congress wants to not just express disapproval, but adopt procedures to express explicit approval of an executive branch regulation, saying, we were vague in writing the statute, but the agencies got it right in interpreting it. And this is the will of Congress, kind of preempting the courts striking it down. On the capacity front, kind of what we've already been talking about a little bit, but Congress should continue to build on the work of the Select Committee on the Modernization of Congress. I think that committee's work was essential in getting Congress to start thinking about itself and its capacity, but needs to go much broader than that committee's work if it's going to kind of adopt the style of legislating that the post Chevron world intends. And so that means increasing staff capacity by kind of expanding the number of committee staff there are, maybe even the number of personal and leadership staff there are, being intentional about recruiting staff that have deep policy expertise rather than just political expertise, giving more resources to its support agencies, both by boosting staff at existing agencies and potentially reviving old agencies, such as the Office of Technology Assessment, or even creating new agencies, such as the Office of Regulatory Review, which has been floated by colleagues at AEI, where kind of Congress would take a more active role in writing actual regulations. More broadly, Congress should update existing statutes related to Congress's access to executive branch information. There's always been this dance between Congress and the executive branch trying to get information from each other. Particularly, the support agencies need a little bit of help. And there's been some recent legislation proposed that would boost the Congressional Research Service and the Congressional Budget Office's ability to get information from federal agencies.
Yeah, GAO has pretty strong authorities to get agency information. Having worked at DHS, I remember we were told GAO asks, you pretty much have to give it to them.
Yeah,
but I don't remember the same coming from CRS or CBO. You're right.
That's exactly right. When I worked at the Modernization Committee, we went to the three support agencies saying, like, what more data access do you need? What existing tools do you need in your toolbox? And GAO was always very clear that we're good. We have what we need.
Yeah.
And then the final thing I think Congress should weigh is kind of more holistically looking at how it uses data and evidence throughout the legislative process. And there was a Modernization Committee recommendation to stand up a congressional evidence-based policymaking commission that would take this systematic look at Congress and the legislative branch to figure out how it accesses, reviews, and uses data. And it sounds radical, but it's really mirrored off a bipartisan commission that existed from Paul Ryan and Patty Murray that did the same thing already for the executive branch. So this would just be
Yeah.
bringing it to Congress.
One of the questions I think that comes up here is, how and where does could the executive branch get this expertise in policy making, which exists mostly in the executive branch? Now, there are ways that congressional offices and committees can have detailees from the executive branch agencies that hopefully would help provide some of that expertise. Do you recommend sort of expanding some of those relationships, that the more that let the Congress and the executive branch are talking to each other, maybe the more of that they can understand sort of what the roles are and how to best meet them?
Yeah, so I think expanding the use of detailees is a great way to get some of the executive branch expertise into Congress. I am a little wary of that as a Congress scholar, in that just have to be careful about how much Congress comes to rely on that agency expertise,
Hmm.
because you don't necessarily want the agencies dictating to Congress
Right.
what policy should be. But another way to kind of accomplish that would be increasing the number of witnesses that are testify before Congress, and the variety of sources of those witnesses, to get Congress hearing from more experts. And there's also models like the British House of Commons. Their committees have websites that they put out, requests for information, where outside experts outside of government can submit reports and analyses to inform the committee's work. So I think kind of this multi-pronged approach would help get information into Congress in ways that don't necessarily require spending a lot more money by hiring more staff.
Yeah. Well, any final thoughts on the impact of this decision as we head into a break?
I'll say it is still very early days. I think it will take years, if not a decade or more, to fully understand the impacts of the end of Chevron deference. But what I do know is that nothing in this ruling will automatically force Congress to be more proactive in how it writes legislation. I'm hopeful that it does shift the incentive structure to maybe make that more likely, if for no other reason than if Congress doesn't adopt this new method of lawmaking, then it will result in more power for the courts.
Yeah. Well, JD, thank you very much for that deep insight into how Congress works. And we will be paying attention to see how its impact. We're going to take a quick break. And when we come back, we'll hear our second expert's thoughts on what Chevron overruling means specifically for immigration policy and law. But JD, thank you so much for joining This Week in Immigration.
Thank you so much for having me.
All right, stay tuned. We'll be right back. Welcome back. Our second guest this week is Mark Stevens, who is a top-rated Washington, D.C. immigration attorney from Clark Hill PLC. He's a lead expert on immigration litigation in federal district courts, deportation defense, business immigration, and appeals. He practices often before U.S. Courts of Appeals, U.S. District Courts, the Department of Labor, the Board of Immigration Appeals in the Department of Justice, immigration courts, U.S. Citizenship and Immigration Services, and the Department of State. He's the author of multiple publications on immigration law, and recently, together with 3 other colleagues, he co-authored a blog for the American Immigration Lawyers Association on the SCOTUS decision overturning Chevron and its impacts on immigration legal practices. We're very pleased that he's agreed to join us today to discuss these impacts on our podcast. So welcome to This Week in Immigration, Mark.
Thank you, Theresa. It's a pleasure to be here.
So, with our previous guest, we discussed the Loper-Bright ruling and the overturn of the Chevron doctrine from a broad, not specifically immigration-focused perspective. But before delving into how it is going to impact immigration, we'd like to touch base on another significant Supreme Court ruling, SEC versus Jarczy. which dealt with administrative law judges. And there's a quasi-judicial process that many administrative agencies have. And the immigration system has a bunch of these, including the immigration courts, as well as immigration-related appeals offices for the Department of Labor, U.S. Citizenship and Immigration Services, and the Department of Justice. So could you tell our audience about this case, what the decision was on it, and how it might affect these particular aspects of immigration?
Sure. So this case is about the Seventh Amendment, and you don't hear people talk about the Seventh Amendment very often. It's one of the more obscure ones, but it's a very important one. And I'll just read it. It's pretty short. What it says is that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. And no fact tried by a jury shall be otherwise reexamined in any court of the United States than according to the rules of the common law. So, to unpack that, what it means is that if someone is suing you for more than $20, then you get a right to a jury trial. And if a jury has decided any of the facts, then those facts cannot be uh, redetermined later by a judge or anyone else. And the reason this is in our Constitution is because of the events that led up to the American Revolution. One of the accusations that the colonists made against King George III is that he was depriving us in many cases of the benefits of trial by jury. That's in the Declaration of Independence. So it's worth noting at the outset that the Seventh Amendment is something that the founding generation fought for and died for, and that's why it's in the Constitution. And so that brings us to Mr. Jarchezi. George Jarchezi and his company were fined for securities fraud. The question was whether the Seventh Amendment gave him the right to a jury trial on the SEC's claim that he had committed fraud. The SEC had a choice where to bring the claim. They could bring it in a federal district court, or they could bring it in their own courts. And it's can be a little bit strange to think of agencies having their own courts, but many of them do. Go back to your high school government class. There's three branches of government: legislative, executive, and judicial. The legislative branch writes the law, the executive enforces it, and the judicial branch interprets it. Now, an agency is weird because they can do all three. They get to write the law, they get to enforce the law, and they get to interpret the law. Now, if you're being sued by the government in an administrative court, then often the prosecutor is going to work for the same agency as the judge. And so, who is the judge going to pay more attention to? Obviously, the prosecutor. The playing field is tilted against you. So, the Seventh Amendment has a two-step analysis. First, is this a suit at common law? And what that means is this similar to a claim that would have gotten a jury trial before 1789 in the courts of England and in the early days of the colonies? If so, then the Seventh Amendment applies. Next, does it fall into one of the exceptions called public rights? And those are areas where, even though the Seventh Amendment applies, claims can be heard without a jury. Now, the confusion and the reason we needed the Jarchezi decision, was that there was confusion about how the Seventh Amendment applied before agencies. In a 1977 decision, Atlas Roofing versus Occupational Safety and Health, the Supreme Court held that Congress can assign claims to an agency, and the agency can hear them without a jury when the government brought the charge. There was two main problems with this. First, the Constitution is a set of laws that Congress can't take away. That's the whole point. So the idea that Congress could take away the right to a jury trial just by passing a statute didn't really make sense. The second problem is that the Bill of Rights was designed to protect the people from their government. It was not designed to protect the people from other people. Okay? And so the idea that the only time the Seventh Amendment didn't apply was when the government was suing you didn't make a lot of sense. So what did the Supreme Court decide in Jarchezi? First, at the first step of the analysis, is it a suit at common law? Is it similar to claims that would have gotten a jury trial before 1789? And here we look at two things. First, we look at the remedy. Is the remedy, in this case, civil money penalties? Is that something that would have gotten a jury trial before 1789? And here the answer was yes. And then second, is the claim similar to a claim that existed at common law? And here the Supreme Court found that the securities fraud claim brought by the SEC was similar to uh, common law fraud claims. So at that first step of the analysis, the Seventh Amendment applies. Now, second, does this fall into one of the exceptions, a so-called public right? Now, here's where the Jarchese decision made the real innovation. There had been no real agreement as to what a public right is. And what the Justice Roberts held was that public rights are the specific areas of law where claims were historically tried without a jury. And he identified about 6 or 7. And so these are the areas where a claim can be heard without a jury, even though the Seventh Amendment applies. And the areas are taxes, customs, immigration, relations with Native American tribes, the administration of public lands, and the granting of public benefits. And benefits means pensions, patents, payments to veterans, and other things like that. So that's a quick rundown on the Jarchese decision.
So let's talk about the various types of administrative agency, I call them tribunals, that exist in the immigration system. Most people are familiar, because we've heard a lot about them lately, of the immigration courts. These are not judicial courts, they are administrative courts run by the Department of Justice that decide when someone in the United States who's not a US citizen can be deported. And obviously, we've talked a lot about their challenges and backlogs. We even had Congresswoman Zoe Lofgren, who's introduced legislation to take the immigration courts out of the Department of Justice and make them independent. But you just said that Chief Justice Roberts, in his decision, said that immigration was an exception to the Seventh Amendment trial by jury. So let's start with the immigration courts. Would they be impacted by this decision?
Probably not, for 2 reasons. First, as you mentioned, immigration is an area of public rights, and so under Jarchese, we don't need a jury. But second, the Seventh Amendment doesn't even come into play because this is not a suit over money. If the government's looking to deport someone, then there's no amount in controversy. And remember, the Seventh Amendment applies when the amount in controversy exceeds $20. So really, Seventh Amendment is about claims for money.
Okay.
And so when the issue is whether someone should be in the country and there's no monetary claim, then we're not going to have a jury trial.
Okay. So let's look at some of the other types of administrative. Department of Labor has a lot of them, but some of them do relate to an immigration process that the Labor Department runs, the labor certification process. So when an employer is trying to hire somebody in the United States and get them a green card or certain types of temporary visas, Department of Labor comes in and the employer has to show they can't find U.S. workers. They have an appeals office called the Board of Alien Labor Certification Appeals, or BALCA, that decides disputes over the approval or disapproval of these kinds of cases. This also sounds like it might meet those exceptions because it's not monetarily around. Is that your understanding as well?
Yeah, Balcom decisions might fall into that exception, but that'll have to be addressed by the courts. I think where you're going to see the impact is where immigration law crosses over into employment law. And the two really do interact because a lot of immigrants are coming here to work, and employment of undocumented people has been seen as a problem at least since the 80s when Congress passed the Immigration Reform and Control Act. And so, just to give an example of some areas that might be impacted, OCAHO, the Office of the Chief Administrative Hearing Office, that's part of DOJ, they can assess fines for hiring undocumented workers, for immigration related unfair employment practices, and also for immigration related document fraud. And those cases are heard by an administrative law judge. And so OCAHO could potentially be implicated. The second example is, as you mentioned, some of the courts of DOL. Now, DOL has courts that can assess fines for violations of various visa rules. For example, in the H-1B program, the H-2A program, and the H-2B program, they can assess civil money penalties. And sometimes DOL will also draw on other more general laws. For example, like the Fair Labor Standards Act. If let's say if an immigrant is not getting paid enough and they bring a claim for unpaid wages. DOL might rely on the Fair Labor Standards Act. And so that's a general rule that's not an immigration rule, and it involves money. And so you might have a Seventh Amendment impact there. Another example is the Migrant and Seasonal Agricultural Worker Protection Act. Some H-2A employers are also regulated under this rule. Now, it might sound like this statute relates to migrants, but it doesn't. It applies to all American workers, basically anyone working in that industry. And so it's going to be at that crossover between employment law and immigration law where you're going to see the impact of Jarchezi, and especially when DOL relies on sort of generally applicable laws rather than laws that are designed just to regulate immigration. And I would mention one last area that is interesting. One area where money changes hands in immigration. If someone has paid a bond to ICE and then they breach the bond, you pay money to get someone out of immigration detention, and then if that person gets a removal order, you're supposed to surrender them to ICE so that they can be removed. If you don't surrender them, you breach the bond and you can lose the bond. Now, that's a monetary claim, but that potentially might fall into that immigration exception that Jarchezi found. So that's where I think you're going to see the impact of Jarchezi.
So it sounds like there's a lot of potential impacts. There's some that are more likely than others, but we're going to have to see. So when we take this case in context with sort of Loper Bright, and it was joined with another case called Relentless on the deference to the government and administrative agencies, it does seem like the Supreme Court is saying, you know what, this idea of the administrative state has kind of gotten really, really big, and we're going to pull it back a little bit and say, first of all, that agencies that have their own sort of quasi judicial systems may or may not be able to continue them. They're going to have to go to courts to get the fines that they're levying or whatever else. And then, secondly, the way that an agency is going to interpret the laws that Congress passes, which does affect how these decisions are made in these administrative tribunals as well. That also is something that the judges have to engage in. When you look at all of that together, how do you think this is going to kind of rebalance in the immigration context? And we've talked about lots of like little corners of the immigration world just now that a lot of people probably don't even know exist. But in the immigration world more broadly, how do you think these two decisions are going to impact the way the government works, the executive agencies involved in immigration, and the courts? Are we going to see more litigation? Are we going to see more immigration cases ending up in federal courts? Are we going to see the agencies themselves maybe taking different angles in how they're going to try to implement the immigration laws? Put on your crystal ball a little bit. What do you think?
Yeah. So these are huge changes, massive changes in the system, and the general message is that it's open season on federal agencies. Okay, we're going to see more litigation challenges. We're going to see more robust litigation. Up until now, if you wanted to challenge an agency, you had to write a huge paragraph, a huge section in your brief over why the agency's view doesn't deserve any deference. You don't have to write that anymore. You can just skip to what is the best interpretation of the law, and then the court can give what they think is the best interpretation of the law. So theoretically, that's a great thing. Now, specifically in the immigration world, though, there is a second message of this Supreme Court, which is that we're not interested in immigration claims. So at the same time as there's a movement to expand the courts for challenges to agencies generally, there is also a movement at this Supreme Court to restrict immigration challenges. And so we are feeling in the immigration bar, we're feeling a little ambivalent. And I'll just give 4 examples where in recent years where the Supreme Court has restricted immigration challenges. A couple weeks ago, in Department of State versus Munoz, the Supreme Court held that a U.S. citizen has no rights in their spouse's visa applications. And this means that visa decisions, a decision made by a consulate to deny a visa, essentially can't be challenged. Now, there may be some little wiggle room left, but we're not quite sure. Second, in 2022, Patel versus Garland, the Supreme Court held that courts lack jurisdiction to review the facts underlying any application for discretionary relief, such as a green card. So if an immigration judge got something wrong when weighing a green card application, you can't get review of that. A third example, DHS versus Theresa, a 2020 decision which held that there's no right to habeas corpus for people detained upon entry to the United States. And then lastly, Jennings versus Rodriguez, a 2018 decision, held that there's no right to regular bond hearings for people in immigration detention. And so this Supreme Court is animated by a conservative judicial philosophy that currently includes various attacks on the administrative state. And that's what we're seeing in Loper Bright and Jarchezi. And I would add another decision, Corner Post, which extended the time for you to challenge an agency's decision. So it's animated by this conservative judicial philosophy and the attacks on the administrative state, but it is also animated by a hostility towards immigration claims specifically. So as we expand rights for people generally, we also may see a contraction of rights in an immigration specific manner. And I think you saw that in Jarchezi, where they carved out immigration as one of the public rights exceptions.
So tell me if I'm right in kind of interpreting what you just said. Individual immigrants may have a harder time filing claims in federal court, but folks who want to challenge big policy decisions, and we've seen a lot of these cases in the last decade of how the government is implementing the immigration system writ large, things like challenging border policies or challenging, for example, President Trump's entry bans on different people from different countries. We've seen an increasing level of those kind of decisions. Do you see that the court may be more open to those kind of challenges if it's not in kind of an individual case context?
Yeah, challenges to new regulations and policies are going to have more oomph behind them. They're going to be able to make more headway. And so we may well see more litigation challenges to big programmatic things, but also for individuals. For example, if you're in a deportation proceeding and you apply for asylum and you argue that you have a fear of persecution on account of a particular social group. Now, that particular social group, that's a term that hasn't been defined by statute, and so the agency has filled the gap. Now, if you think that they're wrong in how they interpreted it, you're going to be able to challenge that in a circuit court of appeal. So that's an area where it might help individuals as well.
Yeah. And with our previous guest, we talked a little bit about how this is going to change, maybe, or might change how Congress legislates on immigration and a lot of other issues if they're going to have to be more detailed. Whereas I mean, you can disagree with me, but having read the INA, there are some parts of the INA that I think are really detailed and others that are really vague.
That's right. That's absolutely right.
And sometimes trying to figure out how pieces of the INA fit together when they seem to contradict each other. There's been a lot of court cases addressing that. And I can see that these decisions may mean that there's going to be more courts engaging in those kind of decision making. You know, the federal judiciary is a very busy place. It's only going to get busier. How do you see some of these? I mean, some of these cases take years and years before they get to conclusion between, you know, initial injunctions and appeals and stays and then merits hearings and then appeals and send back to lower courts. We could be in an unsettled territory for quite a long time.
Yeah, I think we're likely to see more diversity throughout the country in terms of views of immigration law because each federal circuit court of appeal will get to give its own view of the law. So we might have more diversity. And then the onus will then fall back on the immigration agencies. How do they want to deal with that? Do they want to adopt more liberal rules that are less likely to be challenged? For example, in the particular social group example, do they want to adopt a more forgiving standard for what a particular social group is so that it can't be challenged and come up with different views in the Ninth Circuit versus the Fifth Circuit? That may well happen. Um, so yeah, that's the type of thing that I expect to see. More diversity, and it'll be interesting to see how the agencies respond to that.
Yeah. So have you had a chance to talk to a lot of your colleagues about the impacts of this? What's the mood in the immigration attorney community to this? That some people are looking at it like, oh, could really benefit my clients, and others like, oh, I'm in trouble.
First of all, you have to be ready to litigate, and a lot of immigration attorneys don't litigate, and so they might not know. They might not be prepared to take a case to court. I'd say it's a minority of attorneys that do litigate. But for people who are prepared to litigate, we are revisiting the rules that we hate, and we're re-examining what is the foundation for those rules. Are they well grounded in the law, or are they not? And is there a good reason why we've just accepted these rules, or did the agency just come up with some nonsense, and everyone else went along with it because we were required to under Chevron? And this gets back to something you were saying earlier, but on the surface, the issue with Chevron deference is when a statute is ambiguous, who gets to decide? Is it the agency or is it the court? But underlying that is a whole big messier question, which you alluded to. When a statute is silent, what happens? And that's the really interesting question now. And we don't really have great answers. We have the start. I see the start of an answer in something called the major questions doctrine, which says that for something that is has massive social implications, you need clear congressional authority to regulate. But for more minor questions, where a statute is silent, we're going to develop a new body of case law for how to read statutes in that context. Now, courts will still have the option to give consideration to the agency's views under a principle called Skidmore deference. But basically, the agency is going to have to convince the judge that their view is right. But the agency is going to come to court on a more even playing field with the person that they're trying to prosecute or challenge.
So this is all very, very fascinating to me. I mean, one of the things that strikes me, and I welcome your sense, we've talked a little bit here about immigration law is predominantly administrative law. It's civil law. It's not criminal law, although there are some parts that have criminal applications. And a lot of recent court cases, particularly challenges to policy, have ended up on the have succeeded or failed based on the Administrative Procedures Act. And there's an intersection here. We're talking about interpretation of statute, but one of the fundamental requirements of an agency promulgating a regulation or a policy under the Administrative Procedures Act is that they have to act within the statute. They have to have authority within the statute, and their regulation has to derive from the statute. There's also notice and comment and procedural issues that they have to come under. Do you think that these decisions are going to mean more of those challenges are going to be based on that you didn't have the right authority in statute to do it, or your claims of what the statute says is don't match, versus these procedural issues? Or do you think they're still both equally going to be out there?
So Loper Bright has thrown the field more wide open, more for substantive challenges. Those challenges you mentioned, where the question is, did an agency act within the law? But these three decisions that we've talked about, they're going to breathe new life into the Administrative Procedure Act. And remember earlier I mentioned how the Constitution doesn't have a spot for administrative agencies. The APA is like the Constitution for the administrative state. You read it, you hear so much about it, then you read it in law school, and it's so short, and you're like, "Is that all that it says?" It's so short, and it is the basis for the way that the citizens interact with the federal government the vast majority of the time. If you're interacting with the federal government, it's almost always through an agency. And so it all comes back to the APA. The APA governs the whole administrative state, and this is going to give new life to APA challenges.
Yeah. So, you do a lot of work in your own practice on business immigration issues, but you also do deportation defense. And how do you see some of these things impacting your personal cases and your practice?
Where we're starting is with some of the areas that I mentioned where immigration and employment law cross over. And we're trying to see if some of the onerous requirements that have been imposed on companies and people, whether those are well founded or whether they're now vulnerable to challenge. And I want to say one thing about Jarchesi and Loper Bright. A lot of the media coverage focuses on how these decisions are going to get rid of all regulation and just allow big companies to ride roughshod over the population. I don't view it that way. Judicial review helps everyone. It helps individuals. It helps companies. And just to take an example in the immigration context, let's say you're a small employer. Let's say you have a corner shop. Every time you hire a worker, you have to check their documents, their immigration documents. And this process is not easy. The government does not make it straightforward or simple. Okay? They can have one document from list A, like a US passport, or they can have one document from list B plus one document from list C. And each list has like 20 examples. And so most employers are probably not doing this exactly right. Okay. And that leaves them open to very large fines. So let's say you run a small store, you hire someone, and they happen to be an asylee, and they show you an I-94 card showing that they were approved for asylum. And you say, well, I've heard that asylum seekers are wrong and they're not supposed to be here, so you don't offer them the job. Well, guess what? You just now committed an immigration related unfair employment practice and you can be fined. Now, who would you rather have hear your case? An agency lawyer or a real judge, someone appointed by Congress to hear cases? Me personally, I think it's a good thing for everyone that we're going to have more judicial review. It's just that we also have this fear that that the Supreme Court is going to find immigration specific ways to restrict judicial review. So as I said, it's a twofold message. We're all very happy. For litigators, we're exuberant, but we're also kind of fearful in terms of how these principles are going to apply. Are they going to be applied neutrally across the board? In many cases, they will. But we're also afraid of this growing hostility towards immigration claims.
So, one thing that I think has maybe caused some people to pause in litigation, and obviously we've talked a lot about the spate of immigration litigation that's happened over the last decade. We even had a long running segment on this show called The Gavel, where we just kind of ran down the latest immigration cases. But one of the things about litigation is it's not cheap. um, and it does require some resources to do, and I think that's one reason why some cases are not brought. But also the question becomes, is it the right case to bring if the judges are now going to determine and understanding like how we interpret the law, depending on the facts of the case, depending on the litigators and on both sides, what comes out of that might be favorable or unfavorable depending on where you stand on the issues. And yet that becomes the precedent that then goes forward. We could see a lot of litigation and it could result in a lot of just more confusion, or we could see some kind of decisions come out that people will say, maybe that wasn't the right case to push forward. I don't know your thoughts about that, but again, it seems like we're in a place where the future of understanding immigration law is kind of up in the air a little bit for those reasons.
Litigation is a tricky beast. You're right, it does cost money. However, in the immigration world and also the employment law world, there are a lot of nonprofits, and they're very good at bringing litigation challenges, and they have a lot of laws to work with as well. Under the Trump administration, we saw countless successful challenges brought by nonprofit groups. Okay.
Mhm.
So the idea that all of this just favors big companies, I don't fully agree with that view.
I mean, judges could come down either way, right? The decision doesn't say that the agencies have no basis to make regulations at all. What it says is that they don't get a leg up
Right.
in determining whether what they did was right or wrong. The judges get to decide that from an equal footing. So the judge may still rule in the agency's favor, right?
Absolutely. The judge is free to agree with the agency's view. And the Loper Bright decision actually encouraged judges to consider whether the agency's view is right. It's just that the agency has to convince the judge that the agency acted within the law. They're not entitled to win just because they are the agency and they have said that this is what the law means. Basically, we're going to have judges judging whether an agency acted within its authority.
Well, that sounds like what they're supposed to do, so maybe this is a good thing.
Absolutely, absolutely. I think that both of these developments that we're talking about, at a very high level, they are good things. Now, how it plays out in different contexts, it could be favorable or disfavorable for different groups. But I think at a very high level, Jarchesi and Loper Bright are good things.
Right. Well, Mark Stevens, I think we're going to leave it there. Thank you so much for joining us for This Week in Immigration and helping us to understand, many of us non-lawyers, to understand the impacts of this. Thank you so much.
Thanks, Theresa. It was a pleasure.
And that's a wrap on this episode of This Week in Immigration. One last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find our podcast episodes on the Bipartisan Policy Center YouTube channel. You can find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow the Bipartisan Policy Center on the X platform at BPC_bipartisan. You can follow Theresa Cardinal Brown at BPC_T Brown, and you can follow me at Jack Malday. Send your comments and feedback to us by email to immigration@bipartisanpolicy.org. I'm Jack Malday. This Week in Immigration was created and executive produced by Theresa Cardinal Brown. This episode was written by myself, Rennie Mockery, and Theresa Cardinal Brown. Joshua Joe is our audio editor. The executive producer of BBC Podcasts is Lucy Manning. Talk to you next time on This Week in Immigration.